Welcome, ladies and gentlemen, to the Saturday HOA Brunch, presented by Angius&Terry, LLP. Please sit back, relax, and join Brad Epstein and Jonathan Broderick for an hour of entertaining information about HOAs and HOA law.
Well, good morning, Sacramento. I hope this doesn't sound unfamiliar, but the original three for the Saturday HOA Brunch are back in studio.
We're back.
And let's first thank Mr. Garth Leone, stepped in, did a great job. Show sounded great. I was down in Modesto, but really everybody that was listening last week sounds like they enjoyed it thoroughly. What do you think, Epstein?
Absolutely. Garth Leone, he was a great co-host and an insurance expert. Great to have him on again, and I think isn't he going to be a sponsor to the show as well?
I think so, yeah. MGA Live. So I think we're still working out some contractual issues, which is interesting because what are we talking about today? Aren't we talking about contracts?
Contracts.
Yeah,
Nice
yeah.
segue.
So maybe I'll learn something and I'll be able to step up toe-to-toe with them and we'll be able to hammer something out soon.
You're going to be able to use our contract form and not his, because that's one of the tips we're going to give the listeners later on today.
Always get it in writing.
Always get it in
Watch
writing.
out for that fine print.
Yeah, so we're the Saturday HOA Brunch. If you want to give us a call, 888-923-1380, 888-923-1380.
Yes, please call in. We're going to start the show. We need to talk about the Sacramento Bee article of September 22nd, last week. Natomas couple settled a long, bitter dispute with homeowners association. And I would like to see if anyone would call it and tell us what they think about this. Actually, this is an article that is, I think it's like a 3-part series.
I think it's
started
one-sided.
a couple years ago. And that's our point. Our point is that homeowners associations in the media, they really get they're cast badly.
Not a
they
fair
really
shake.
Are. Yeah, exactly. They're always
the evildoers in every story.
right. So, they make the story as the homeowners are the David against the community association is the Goliath. Long-running battle shows difficulty of challenging a homeowners association. That's the tagline there. Long-running battle shows difficulty of challenging a homeowners association. So, it's this David versus Goliath, and that the associations are wrong. They're dictators on the board of directors, and then they always throw in the attorneys. The attorneys are these horrible people that are cheating.
Sharks.
Exactly.
Yeah, well, I have a question. Would everybody like to work with these great management companies and private industry partners, or do you want to have somebody in a suit show up in your association, like the IRS, and say, okay, here's how we're going to run things? What do you think about that?
Yeah, well, one of the points that it's Hudson Sangre with the Sacramento Bee. And what he is, it's like a tabloid article. He is saying that, associations have inordinate power compared to individual homeowners. And he's saying there's no governmental oversight of community associations. And that's not true. For instance, this article's all about the DFEH getting involved with respect to a homeowner who complains about that the association was not allowing him to use a chairlift at the pool. The DFEH is the California Department of Fair Employment and Housing. And the Attorney General also gets involved because associations are corporations, right, you guys?
Right.
Yeah.
Mutual benefit nonprofit corporations. And they're saying there's no oversight. And now, like you said, the story is completely one-sided. It is. I do have to concede the fact that the association, neither its board or council, decided to go ahead and give a comment, a counter comment.
Yeah, and their comment, you got it?
Right.
You got it?
They decided not to.
Oh, not to. Okay.
Well, according to the article.
I didn't even want to read it. Once you told me about it, it was so one-sided, and it just,
Well, it seems that the author also didn't go out of his way to really talk to the other side and see what was driving this lawsuit or what the dispute was really about from the other side's perspective. So
yeah,
that would have been interesting to hear, because we really don't know the whole story. We only know what one side reports. So
right, and why did it make sense for this reporter to go out to Marjorie Murray? She's president of the Center for California Homeowners Association Law in Oakland. It says it's an advocacy group for HOA residents. I'm familiar with her. Marjorie Murray, she didn't have anything to do with this story at all, and yet he's asking what her input is. So anyone wants to talk to us about this, that would be great. Otherwise, we're going to move on to our topic of the day.
Contracts, right?
Contracts.
Oh, such an important piece of making the association function properly, right? Is having good contracts.
Right, and where do we always start when we talk about any of these legal topics? It is the law, the legal authority on community associations, which is the Davis-Sterling Act. And coincidentally, that is also some authority on how associations should be run. So maybe there isn't any direct oversight, as this author points out, but there is some law, and the associations are always hopefully following the law when it comes to whatever they're doing, whether it's enforcement or contracts. So there isn't that much information on contracts in the Davis-Sterling Act, is there, Brad?
No, not really. What you have is starting things out. In order for a board of directors to have an association enter into a contract, they need to have a meeting, right? They need to have a meeting, and like all boards, they need to determine whether they're going to make this decision in open session or executive session. So what's the difference between open session and executive session?
So the open session board meetings are the ones that where most matters are discussed. The owners can participate or at least listen in. It's an open meeting. Everybody's allowed to not participate, but attend. And the executive session is reserved for certain kinds of matters where the board meets in a closed session. No one else but the board or maybe a third-party contract vendor may attend to discuss certain particular issues, which are usually member discipline, personnel matters, meet with a member upon the member's request, discuss payment of assessments, or formation of contracts.
Right, so there's only particular specified items that boards can meet in executive session, that is excluding everyone else. And it's sort of the version for associations of the Brown Act, right, Jonathan?
Sounds like that's way before my time. I don't know. Explain the Brown Act.
The Brown Act is the Open Meeting Act for governmental entities in California.
Oh, yeah. I was just flipping through my memory, and now that rings a bell.
Right, you remember that. So executive session for community associations, and they may discuss the formation of contracts with third parties, quote unquote, pursuant to Civil Code Section 4935 of the Davis-Sterling Act. Boards do not have to meet in executive session to form a contract with third party, but they may. And why would you? Why would a board want to do that, you guys? To protect, it's trying to make the negotiations a little bit more fair, maybe to be able to talk freely about third parties without having them attack them for what they say about them.
Exactly. It seems like it would just be the environment would be more efficient for making a good decision for the association as a whole, right? In executive session, you have this huge contract in front of you. You're going to have 10 or 15 people out in the audience, chiming in and trying to tell you, no.
That's a good point. I wanted to mention that. So if you have an open session, right, your board of directors, and the way it is, the board of directors will be at tables or chairs that are maybe in a semicircle.
I like the meetings in Nevada because they put your name up. They have to put it up, of everybody that's sitting up on the panel or all of the vendors that arrive. So it was nice. I had my name up there, and that's special.
Oh, as a guest at a board meeting.
As a guest, yeah.
Yeah, I remember that. And so what the board of directors, though, they are running the meeting. The owners, they're not participating in the meeting at all except to do the open forum. So they can't just chime in. You can't have a meeting that's going to be successful if the owners are chiming in. Some boards let them chime in.
Yeah, but that doesn't stop them.
And too long.
Oftentimes.
Hey, so we're getting the signal from our legend in the back, Mr. Frank Jolly, that it's time for us to go to break. Hey, Frank, I just want to give a shout out to Folsom Live tonight. You heard about that, Epstein?
Yeah, that's exciting.
No
concerts. Eddie Money though. So.
No Eddie Money this year, but some other good shows.
Frank, how are you doing today, Frank?
He's back there shaking his head. So, yeah, and we'll be up there, Lockdown Brewery tonight. So, we hope to see everybody out at
Another
Folsom
one of
Live.
our sponsors, right?
Yeah. We're still working on the contract.
Okay. So when we come back, we're going to talk about different provisions of contracts.
Right.
The conservative countdown has begun. Choices Charter School presents the GOP Smackdown. Insiders versus outsiders.
Our politicians are all talk, no action.
The problem with Mr. Trump's language is it's divisive, it's ugly, it's mean-spirited.
Our leaders are stupid. Our politicians are stupid. And that's what's happening, whether you like it or not.
Donald Trump's candidacy is a cancer on conservatism.
I think he's highly overrated. And by the way, I have much better hair than he does, okay?
The GOP Smackdown. Insiders versus outsiders. Featuring Michael Medved and Congressman Tom McClintock. Plus, Phil Cowan and Ed Crane. Sunday, October 11th at William Jessup University in Rockland. This just in. Tickets to the GOP Smackdown with Michael Medved are free. Get them at Capital Yamaha on Auburn Boulevard or at Oil Stop in Roseville. Join the conversation and start the clock on October 11th. Find all the details at am1380theanswer.com. Keyword GOP.
If your community association has a good relationship with their current management company, you can stop listening. However, if you are struggling with your current service provider, we'd love to talk with you to see if Omni Community Management would be a good fit. Transparency, education, communication, and trust are just 4 of the qualities that set Omni apart. This is Rolf Crocker, CEO of Omni. Call us at 916-965-8964. That's 916-965-8964. Online at omni-mgt.com. That's omni-mgt.com. Omni Community Management, your friend in the community association management industry for over 20 years.
Have you ever heard of the saying, a person's home is their castle? Of course you have. But sometimes a construction defect can turn your castle into a catastrophe. If this happens to you, you need proper and professional representation. You need Angius&Terry, LLP. For over 30 years, the attorneys at Angius&Terry have been effectively serving homeowners and community associations, recovering more than $500 million on behalf of their clients. Angius&Terry strives to ensure that your construction defect claims are prosecuted in an aggressive and cost-effective manner. Angius&Terry will also continue to work with homeowners and community associations after the construction defect claims are concluded to make sure that the money received from builders is spent wisely and that your interests are protected during the repair process. Don't let a construction defect turn your castle into a catastrophe. Call Angius&Terry LLP today at 916-567-1400. That's 916-567-1400. Online at angius-terry.com. Angius&Terry LLP.
This is AM 1380. The Answer.
You're listening to the Saturday HOA Brunch presented by Angius&Terry LLP. And now your hosts Brad Epstein and Jonathan Broderick on AM 1380, The Answer.
Hey, we're back. It's the Saturday HOA Brunch, stepping into the second quarter. This is great. Frank's got BYU Michigan on TV, so we can watch a little football while we talk a little homeowners association. So let's check in with one of our contestants today for Battle of the Board members. Mary.
Yes, good morning.
Good morning. How are you doing?
I'm just great.
Well, I've got a couple of questions for you, and then you can just go ahead and listen to the legal discussion and prepare yourself for the big battle towards the end of the show. How long have you been a board member?
Just about 6 months.
6 months. Okay. Now, do you prefer as a board to discuss your contracts in an open meeting or in an executive session?
Mostly an executive session.
Mostly an executive session. And why do you feel like that's what you guys gravitate towards when you have to make a decision on a contract?
Well, we can talk very freely and put a kind of a short presentation together to give during an open meeting.
Yeah. Okay. I think that a lot of heads are nodding in studio, right?
Yeah, that makes sense. Well, thanks, Mary.
Hey, Mary, so just hang on the line now. Listen to this legal discussion by the two attorneys in the room, and then we're going to get your other contestant on the line. And towards the end of the show, you guys are going to answer some true or false trivia questions and win yourself a little gift card. How's that sound?
Sounds good.
Great.
All right, so you know what I want to always talk about is do's and don'ts. I love do's and don'ts. So we're going to have to talk about some do's to start with on contract formation. So one of the top do's is always use a written contract you use a written form. And then there's some reasons for that, some obvious reasons. First of all, you want to know exactly what was agreed upon between the parties, and if you have it in writing, it's easier to consult. And also, if any contracts are to be performed within a year or more, they always need to be in writing because they violate the statute of frauds if they are not.
Statute of frauds. Now, what is the statute of frauds?
Oh, geez. Are we going to delve into that?
I have just with Viana, though, with your experience, a lot of this knowledge, though, it can be applied in contracts in a variety of a lot of different business, right?
Different parties, yeah.
Parties and stuff. So this could be, a contract if someone's putting in a pool. These are all things that you can take notes to yourself, do's and don'ts, to make sure that you have some certain things in your contracts to protect yourself.
Oh yeah, these apply to all different kinds of contracts. These aren't just with contractors,
right?
With someone who's going to do some work, repair your roof or your siding or anything like that. Yeah, that's a good point, Jonathan.
Yeah, so these are applicable, right, to a variety
They're
of.
Very applicable.
And they're not just for associations either. I mean, any two parties should probably do these things.
Okay, the statute of frauds. Everyone should know this one. This is a fun one. Everyone learns this in law school. This is the law that provides that if your contract is not in writing, then it's not going to be enforceable. So
and I don't think email doesn't count as writing.
Wait, why not?
Well,
that's not true.
It's a little bit vague, though, right?
Well, hang on. So, as a layperson, you raise the issue. So let's talk about that. Is an email, is that sufficient for a contract?
I would think so. It depends on.
I don't think I would want to enter into a contract via email.
What about via Post-it? I mean, hey, that's
what
a
about
possibility.
electronic signatures now? Electronic signatures are a
all
big way of going.
Let me clarify. I was talking about open, send, hey, let's do the roof for $10,000. Thanks a lot. And then you reply, oh, okay, that sounds good. I'm not talking about we're sending a PDF of a 10-page contract.
No, that's a contract right there.
That's a contract right there.
Jonathan,
if anybody does
he's
that,
dubious.
yeah, but I just
why? What's wrong with that?
I want to know how many contracts Jonathan's entered into without knowing.
I got to sit down and feel it and look through it and highlight it.
Oh, you're old school. You have to have an in-person meeting.
Hey, you're
with
still
a
reading the
10-page
SAC
contract,
and you have a hard copy in front of you. So who are you calling old school?
Who are you calling old? Okay, yeah, always use written contracts. And go ahead, Viana. I think you're going to talk about...
the next one is also a big one. Always require insurance and proof of insurance, and we're going to delve into that a little bit later about what type and how much insurance you should have. But if you're going to hire a vendor or a contractor, they better have insurance. Also, you want to specify the independent contractor status of the contractor you're hiring, and always review the scope of work. That's extremely important because you want to make sure that you understand what the vendor is going to be doing, and the vendor understands your expectations about what work they're going to be doing. And always confirm the vendor's current license, their contractor's license. And
easy to do, right?
Information. Yeah, it doesn't.
How easy is it to do?
You just go to the California State Contractors Board website and you just punch in their number. They have a link there. You
their name,
you scroll
their
down,
number,
enter it, and it'll say, what is it? I don't know the exact language that they use, but it'll tell you whether or not it's expired or if it's been suspended or right or
That's
if it's
right,
active
absolutely.
and they have no issues with it.
And it is completely free. Just we have to make that clear that if you don't know if your contractor is licensed, it's all on you because it's really easy to access. It is completely free. It only takes about 5 minutes. So always confirm that they have a current license. And probably the most important thing is never ignore contract deadlines. I mean, payment deadlines, notices. A lot of contracts have termination clauses that say that if you want to terminate the contract, you must notify the other party within 60 days before the end of the contract or 30 days. So if you miss that deadline, you might be in trouble.
Right. So those are for those long-term contracts. Back to independent contractor status. That's a little confusing. So let's just make some little bit more detail on that. So independent contractor status, that's the opposite of that is you're an employee. Mm-hmm. So what you have in the contract, you have a clause that says that the contractor is an independent contractor, that they're not an employee of the association. And that's important when it comes to what we've been talking about lately with Garth Leone, and that is workers' compensation.
That Hyman case, right?
And the Hyman case. Right. And what you want to avoid is if someone gets hurt, the contractor, staff, and any of their employees, that they're not deemed to be an employee of the association, where the association is on the hook for the medical payments for the hurt contractor's employee. So independent contractor, not an employee. One thing also I want to emphasize that you mentioned, Viana, is the scope of work. This is super important in that oftentimes the board of directors, they know what they need to have done. The contractor, they've been doing this for years, and so they know what needs to be done. Well, you need to have a meeting of the minds there. You need to make sure that the scope of work is sufficiently detailed, right?
I think so. I mean, it could get kind of broad if you were going to, reskin one side of your building. It's 2 stories, and the contractor writes on the scope, east building, second elevation, 280 square feet of siding. Well, which 280 square feet is it, right?
Yeah.
Unless you exactly sit there and identify and mark all of the different areas that you're going to replace, right? I mean, I'm sure that most of these contractors are fair and they're not going to try to sneak one by you or anything like that. But I mean, haven't you seen it over the years?
Are you trying to say that the detail has to be sufficient, but it can't be overkill so that it makes it confusing?
Right. But it does need to be pretty clear when you get your scope of work, and they probably need to be apples to apples with what? You should probably get 3 bids, right, Viana? So everybody should be, no?
You should at least get a few bids. You don't want just one bid, but that's...
Disagree.
Counterpoint.
Point, counterpoint. Yeah, what do you think about multiple bids?
It matters what kind of contract you're entering into.
Okay, that makes sense.
It matters, right, what the amount of the contract is. It's ridiculous to get 3 bids for every contract that an association enters into. That doesn't make any sense at all. Okay, is there small dollar amounts, right?
Yeah, I could see.
There might not be enough vendors to have 3 contracts. Like if Comcast is the only vendor that is in your area, then
then you got to call Morgan Fussell from Broadband Agreements.
He's going to be able to
He'll
negotiate a better contract.
He will negotiate it for you.
One of our great sponsors. Okay. So continue, Fiona. Now, beware of certain terms?
Oh, yeah. So one of them you already mentioned, vague or inadequate scope of work. If there's no meeting of the minds and the vendor doesn't really know what your expectations are, you don't know what they're going to do, that's a big problem. So make sure your scope of work is adequate. Tight payment deadlines. Sometimes you're more concerned with the scope of work, the length of the contract, and you're not really looking at the timing of the payment deadlines. So make sure they're not too tight for you to make the payments on time. Automatic renewal provisions for service of contracts. You have to make sure that they don't that the contracts do not renew automatically, or if they do, you have to be aware of what you need to do to terminate the contract.
Fiona, correct me and Brad too. These contracts? Is it usually that people expect payment in 30 days, or can you guys as attorneys assist the board of directors and lighten up the load on maybe the community manager us to cut the checks for them and say, hey, we want to move the payment schedule out 45 days or maybe even 60 days?
That's part of the negotiation process. If the vendor is agreeable to that, you can make the payment whatever you want. If, of course, a lot of them have a preference and they have their own system of accounting where they prefer payments in certain deadlines.
Sure. Yeah. Think about it. I always like to think about it this way. Board of directors for community associations meet no more frequently on a regular basis than every 30 days. So why would you put in payment terms of less than 30 days? That if your board of directors wants to actually meet to see the progress of the job. So, we're like a roofing contract or siding contract. Make it more than 30 days between payments that the board of directors can actually confirm with the manager and have a meeting and determine to make the next payment.
Yeah, Brad, I really wanted to hear from you on limitation of liability clauses. Why are those something to be aware of?
Yeah, so limitation of liability clauses, and they are frequently in landscape contracts, landscape installation contracts, landscape architect contracts. Those are primarily where you'll find limitation of liability clauses, and these are provisions that say that the liability of the architect or the landscape architect are limited to a particular dollar amount, and it might be the amount under the contract. Let's say that the contract is something typical for an landscape architect, maybe $10,000 to go ahead and design some landscape design. And in the contract will say that no matter whatever liability that flows out of this contract, the landscape architect's liability is limited to the amount of the contract, and something like that, a low amount. And it is something that you want to be very wary of. And typically we will get those stricken or at least negotiated, because if there's going to be liability in a design contract, the liability in particular would be something like for construction defects. design of construction.
I'll be interested to see what these landscapers and architectural designers do with this new turf issue that's hit community associations. That ought to be interesting, right? You think?
Oh, the law that says that community associations
put your
have to
putting
allow
green
owners
in.
to have turf.
Absolutely. Hey, so we're going to come back from break, and we will hopefully get a hold of our other caller. And right, Bianna, what are we going to do? Play Battle of the Board Members?
Battle of the Board Members coming up soon.
Great. Come back and join us.
Did you see the story about the Homeowners Association? I wonder what their residents think.
I don't know, but I love my condominium association. The place looks great and is well managed, and our property values are increasing.
Well, that's a good thing.
Community Associations Institute, CAI, has helped us build a great community. They have tools for safeguarding our investment, including education for our board and professional training for our manager. Just visit CAI at responsiblecommunities.com.
Okay, responsiblecommunities.com.
Hi, this is Rick Russo, owner of Russo Insurance Agency and Financial Services. We proudly serve Granite Bay, Roseville, Rockland, Sacramento, Lake Tahoe, and the surrounding areas. At Russo Insurance Agency, we like to say, get to know us before you need us. Our insurance agency is built on relationships and trust. If you want to be certain that your most valuable assets are insured correctly, allow us to give you more than just a 15-minute quote. For all your commercial, home, auto, and life insurance needs, call us today at 916-791-1901. That's 916-791-1901, or online at rickrussoinsurance.com. That's rickrussoinsurance.com. Thank you.
This is AM 1380, The Answer.
You're listening to the Saturday HOA Brunch presented by Angius&Terry, LLP. And now your hosts, Brad Epstein and Jonathan Broderick on AM 1380, The Answer.
We're back, and we're talking about contracts today, contracts for homeowner associations, but as Jonathan pointed out earlier, they don't necessarily apply only to homeowner associations. So these are good tips, do's and don'ts, things to be aware of when you're entering into any kind of contract. And earlier we were talking about certain things to be aware of, and Brad talked about the limitation of liability clauses, but there's another important clause that we should be aware of, and what's that?
That is the indemnification clause. And this is something that's kind of, it seems to be a little bit confusing to a lot of board members. So let's clarify that. Indemnification clauses. And when you indemnify someone, you're basically acting as an insurance company. This is what insurance companies do. They are indemnifying their insured. So the different parties you have in indemnification clauses, the indemnitor, the indemnity, and then the third party that is claiming liability. So the indemnitor, that is going to be the contractor. The indemnity, that is going to be the association. And then it could be someone claiming liability, such as a homeowner. So let's give an example. Let's figure this out.
Let's talk about landscaping. You mentioned that one.
Landscaping, you threw that's a curveball at me. So what you have is you have a homeowner association, and they enter into a contract with the landscaper. They go ahead and they install the landscaping, and a homeowner is walking through the development, and they trip and fall because there is a drip line that is too high, and they fall and they hurt their ankle, and they're going to now sue the association. And if you have an indemnification clause, then you have the landscaper who's going to indemnify the association for the liability that the association may incur as a result of the homeowner. So the indemnitor, the landscaper, they're going to have to hold harmless, defend, and indemnify, pay for the liability that the association incurs from the homeowner suing. So the homeowner sues the association, and the landscaper, they cover the liability for the association. That's the indemnification clause.
And then the Sacramento Bee writes a big one-sided article on behalf of the homeowner, right? Seems to be the trend this week.
Hey, if you have a good indemnification clause, maybe they'll write about that.
Yeah, exactly. Yeah.
So another thing to be aware of in contracts is the manufacturer's warranty language. I don't think that's applicable to a lot of contracts, but oftentimes you do see that the manufacturer will only provide warranty for products for a limited period of time.
That's a really good point. And oftentimes we don't think of that, because what you'll have is you'll have an installer, right? Jonathan, who's installing siding.
Yeah, like hardy siding.
Hardy siding.
Right, there you go.
Hardy board. And so what happens is you really, the association may forget that, there's another party here, in that there's being a product being supplied by Hardy. And so you want to look at the warranty of Hardy in addition to the warranty of the installer. Right,
because I believe there's a certain way that you have to install the Hardy and use their products,
right side up,
nails, caulking, and all of that. No, but there's actually you get a certification through the manufacturer.
Oh, absolutely, they'll come out and check it,
and they'll come out and they'll check it, and they'll go, no.
Yeah, we had a great construction defect case where the siding was installed the wrong side
upside
up.
down?
Right, upside
down.
That's
cool.
Right, literally turned the piece of siding around, and there's an arrow, and it said, install this side up.
Frank's in shock right now.
And the arrow is pointing down. And so when it comes to construction defect claims, then you have not only the installer that you would make a claim against, but also
the manufacturer. So the last thing we want to talk about being aware of in contracts is the mandatory arbitration requirements. And I know in the past we may have mentioned that maybe you don't want an arbitration clause in your contract, but sometimes it can be beneficial. So it really depends on the contract, but you should be aware if there is a mandatory arbitration requirement in the contract, you should be aware of it, because what does that mean? That means that you may not be able to go directly to the courts and sue. You may not be able to sue at all. So if a dispute arises, that clause will say that the two parties will have to go through arbitration instead of filing a lawsuit in court. So if you are being denied the right to sue, you might want to be aware of that. And sometimes it might be beneficial depending on the contract.
Right. So arbitration, that's when you have a trial, but it's not in court. It's
rent-a-judge?
It's a rent-a-judge. It's outside. Right. Also, statute of limitations. We briefly mentioned the statute of frauds. We're hitting it all today. Yeah. This is like a law class today. And statute of limitations are deadlines for plaintiffs to sue. And so sometimes the contract will put in there a limitation, a shortening of the statute of limitations for a contract. Never. Do not...
Why would you do that?
Well, if you're negotiating and you get such a great deal with a contractor, some board of directors may be tempted to go ahead and agree to whatever the contractor puts in front of them. Furthermore, we do see in a representation of associations where a previous board, never the current board, but the previous board had failed to get their counsel to do a quick 1-hour review of the contract to make sure that it doesn't have these terrible provisions.
Yeah, and that's minimal, right? If you're going to go into if you're going to go into a pretty giant contract, for example, let's stick with landscaping. So say that now they're going to put artificial turf on all of the common area, okay? And they're going to spend $75,000 for this project. Why wouldn't they take an hour or two of an attorney's time, their counsel, and just say, hey, why don't you just go through this real quick, make sure that we're going to make sure we
protect our rights,
cross our T's and dot our I's,
protect our rights.
And what minimal cost? A couple hours of bill time for that?
Exactly.
Yeah.
And so a couple of things I want to hit on before we hit battle of the board members, because I don't want our contestants to not know the answers to these questions, is a couple of things is insurance and bids. I want to talk about bids because we mentioned that sometimes you do have to get several bids for a contract. So if you're going to get several bids, you're going to compare them. You want to make sure that the scope of work in each bid is the same. So you want to compare apples to apples and make sure that you're getting a fair contract from both of them, and that everything is clear. So you're not comparing apples to oranges. Also, if the work is to be completed in phases, you want to make sure that each phase is defined, so you know exactly what you're getting, when it will begin, when it will end, and what will be accomplished during each phase. And then I really want to talk about insurance as well, because as we mentioned, Garth, the workers' compensation issue, we want to make sure that the vendor you're hiring, the contractor, is adequately insured. And all policies should be written by insurance companies with a best rating of no less than A-. That's our recommendation. I don't know why you'd want somebody that's insured by a B-rate insurance, but...
Yeah, because what happens if you sign a contract with a contractor that you are anticipating is going to do the whole project, but then they have a little clause in there or something that says, well, we're going to use a subcontractor for portions of this project. And what if the subcontractor doesn't have the insurance necessary for the project? Is that an issue that comes up occasionally? So you have the general contractor comes in, I've got my $2 million, $1 million, the whole shebang for a homeowners association, but then he hires a subcontractor. is it also important to verify that any subcontractors they're going to use have adequate insurance, or does it not matter because they're underneath the general contractor?
Well, that's an excellent point. And so what you want to have in your contract is a provision that any subcontractors must carry the same insurance. The contract is between the association and the contract, not the subcontractors. However, the more insurance, the better. Additional insurance, associations should be additional insurance as well, right?
Right, that's really important as well. And just remember that directors have fiduciary duty to act in the best interests of the association as a whole. So hire an expert if you're not sure about the insurance requirements, the contracts, any of those issues.
Hey, we're going to go to break. Hopefully our second contestant calls in. If not, you know what? We're just going to have Mary step up, and we're just going to test her knowledge and see what she's learned after 6 months. We'll be back shortly.
Hi, I'm Morgan Fussell. My company, Broadband Agreements, negotiates cable television and broadband right of entry, access, and compensation agreements for your communities. At Broadband Agreements, we offer a free review of all agreements with a signed letter of authorization. Broadband Agreements will improve your community's income and/or savings, or you don't pay us a dime. Visit us at broadbandagreements.com. That's broadbandagreements.com. Or call me, Morgan Fussell, directly at 916-939-5026. That's 916-939-5026. Broadband Agreements online at broadbandagreements.com or 916-939-5026.
The challenges presented by today's economy and rebounding housing market is forcing many homeowners association boards of directors to operate their HOAs more like a business. It's a balancing act of trying to stay solvent and still provide homeowners with quality amenities and services. One of the main challenges HOA boards are facing is attempting to recover unpaid HOA fees owed by delinquent homeowners. Collection efforts are often very time-consuming. If you want to get the HOA fees collection monkey off of your back, call ATC Assessment Collection Group. ATC is an attorney-supervised collection company, providing collection and foreclosure services to HOAs in both California and Nevada's most recognizable communities. Get back to what you actually volunteered to do as an HOA board member. Effectively oversee your community. Call ATC today at 916-641-1410. That's 916-641-1410. Online at atcacg.com. That's atcacg.com. ATC Assessment Collection Group.
News, opinion, insight. AM 1380. The Answer.
You're listening to the Saturday HOA Brunch presented by Angius&Terry, LLP. And now your hosts, Brad Epstein and Jonathan Broderick on AM 1380, The Answer.
Welcome back. So we're talking about community associations and their contracts. And we've gone through all different aspects, wealth of knowledge. And now it's time for our favorite part of the show, the board game. And that's the quiz. And today we have Mary. Mary, welcome again. How are you?
I'm fine.
Great. Excellent. Have you been able to listen to the show and hear all our legal tidbits on association contracts?
Boy, you really provided a lot of good information here. I've been taking notes, and it's a lot of things to remember, a lot of things that really help you, whether you're an HOA or just a homeowner.
You know, that's so nice of you to say.
I would agree. Thank you.
You're so humble, Jonathan. And Mary, we are so happy that you're on the line to play. Jonathan, what are our rules?
Well, every once in a while, you got to shake things up. Unfortunately, I think something came up. Our other contestant, you never know what happened. He wasn't able to call in. So what we're going to do, Mary, is we've got 22 questions, okay?
That's a lot of
It's questions. A lot of questions. We're going to buzz
through. Do you have at least 2 hours?
So here we go. So if you get 15 or more correct, we're going to give you a $100 gift card of your choice. If you get 9 or more correct, $75. And if you get only 6 or more correct, we're going to give you $50. How about that, Mary?
Okay.
So that's, 6 out of 22.
Mary sounds like a good sport.
And she said there was so much good information. She's probably going to nail it 100%. Ace the board member
But there's
game.
no pressure at all. All right, so True, false, Mary. I'm going to give you a series of 3, and the first question is. Oh, are you ready?
Yes.
Okay. Question number 1. True.
And you the rules also forgot to mention that you could repeat them. I mean, she's under a lot of pressure to answer 22 questions.
Right.
So, Mary, if you don't understand or you can't hear the question, you could ask for it to be repeated.
Okay.
Okay. Question number 1. Association contracts should only be in written form.
True.
She said true?
Got it.
I think she said true. Did you say true?
Yes, I did.
Excellent. Nice job. Arbitration clauses in contracts provide for resolution of disputes outside of court. I'll say that one again. Arbitration clauses in contracts provide for resolution of disputes outside of court.
True.
That's right. True. Good job, Mary.
She's on a roll.
On a roll. Number 3. Limitation of liability clauses in association contracts on behalf of the contractor are a good idea.
No.
That's right.
That's
Correct.
awesome.
3 for 3. All right.
Excellent.
Jonathan, you're up. So
Yeah,
Jonathan's going to
okay.
give you 3 questions.
So here we go, Mary. We're going to. Do you need to step away, finish making breakfast or anything? We got a little time, or are you good? Do you want to move forward?
No, I'm good. I'm good.
All right, let's get these 3 questions then. Board discussions about formation of contracts should be held in executive session.
True.
Got it. A pitfall to avoid is a provision that requires payment in less than 30 days.
I'm sorry, what was that?
A pitfall to avoid is a provision that requires payment in less than 30 days.
True.
Got it. Provisions that shorten the statutes. I can't even. This is like a tongue twister for me this morning. I don't know why. Statute of limitations in a contract are favorable for the association. Provisions that shorten the statute of limitations in a contract are favorable for the association.
No. False.
False.
Wow,
Yeah.
she's
That's
6
correct.
for 6.
Okay, so Mary knows what a statute of limitations is. Let's
Yeah.
make sure our listeners know, because it's really important. This is what it's all about to be a board member, to know that there are specific deadlines in order to make a claim. That is, a claim in a contract would be a claim against a contractor. A claim in a construction defect case is when you want the deadline to make a claim against the developer or the contractor. It's the deadline for a plaintiff to file a lawsuit. Round 2. Mary, you're doing great.
She's got 6 for 6.
6 for 6. Question number 1 in round 2 is: contracts between associations and contractors should not require the contractor to carry workers' compensation insurance.
False.
Right? Contractors should always carry workers' compensation insurance. In fact, it is a state law for a contractor. That's more than one person. We're not talking about just sole proprietors. Number 2, as part of the bidding process, the scope of work in each bid should be the same.
I'm sorry, could you repeat that?
As part of the bidding process, the scope of work in each bid should be the same.
Yes.
Exactly. Nice job, Mary. Number 3, contracts should require associations to be named as additional insureds.
I'm sorry, can you repeat that?
Contracts should require associations to be named as additional insureds.
No.
Oh, you got it wrong. Oh, we caught her on that one. So the question, she probably didn't even hear the question right. So contracts should require associations to be named as additional insureds. That's right. So if you're going to have a contract with a roofer or siding guy, then you want to make sure the association is also on the contractor's insurance policy as additional insured. What this will provide is that the association, instead of having to sue the party or they have the coverage automatically, just like a contractor, right alongside the contractor if anyone sues them.
Okay, I understand now.
Yeah, it's like hand in hand with the indemnification provision.
All right, so what is that? Be on a 8 out of 9?
Yep, 8 out of 9. That's
8
really
out of 9.
impressive.
She's on a roll. All right, let's keep heading after the big gift card. All right, Mary?
Might as well.
All right. The indemnitor in an indemnity clause is the party that covers the third party's claims. Mary?
Okay, repeat that, please.
Oh, boy, this is a tough one even for me. The indemnitor in an indemnity clause is the party that covers third-party claims.
Yes, true.
All right. Well, let me see where I'm at. It looks like you got... Okay, next question. Sorry, I got distracted there, Mary. An additional insured clause provides that the insurer must cover the additional insured's liability.
True.
Got it.
Wow.
If work is to be performed in phases in a construction contract, timing for completion should be clearly defined.
True.
Ooh, Fiona, I've got false on here on that one, so that's all right, though.
No,
Brad?
it's actually true.
Is it?
It is.
Well,
it
that's
is
my
actually
fault.
true.
Man, what are you guys doing to me here?
Yeah, we're just gonna, forget what the real answer is. No, she
That's
actually
my
got
fault.
that right. That's 11 out of 12 for
Dirty
Mary. and
trick
that's
after
really
my week
impressive.
outside of studio. Thanks a lot.
Exactly.
And I gotta tell you, I'm really excited because Brad has handed the baton over to me for the lightning round for the first time ever. In the history of the show, I get to ask some of the questions of the contestants, so I'm very excited about this, Mary.
Please do. I'm stumbling over here.
Yeah, I'm sure I'm going to read them much better than you, Jonathan. So, Mary, are you ready for the next 5 questions? We're going to do 5
I'm ready.
questions. Great.
Okay.
So the first one is, directors should consult with their attorney if they do not understand all of the legal contractual terms.
True.
Perfect. Number 2. The scope of work in a contract should only be defined by the contractor.
False.
Great. Number 3. For construction contracts, there should be a requirement that the contractor carries insurance.
True.
Perfect. Number 4. It is very expensive for associations to obtain all the relevant information about a contractor prior to hiring them.
False.
Great. And number 5. An independent contractor clause means the contractor is not an association employee.
True.
Wow, that's really good. So you got 16 out of 17. We only have a couple more minutes. I'm going to go through these really fast, Mary.
Doing such a fantastic job on this balmy Saturday.
It's already fall, though. Doesn't it start September 23rd is when fall starts?
It is
It's
already
a balmy
fall.
fall.
It's a balmy fall.
Nah, I'm
yeah.
waiting for El Nino.
You know what? Mary's already in the $100 gift certificate status. She's got 16 out of 17. But you know what? I really want to ask her. Let's see if she can get more of these.
Plus, our listeners like to play along.
Yeah, so I have a couple more for you, Mary. Number
Okay.
1. It is important to have a clearly defined termination clause.
True.
Perfect. Notice of termination of a contract should be in writing.
True.
Perfect. Number 3, a mediated settlement of a contractual dispute is a negotiated settlement. Ooh, this is a curveball.
I'm sorry. Could you repeat that?
Yeah, a mediated settlement of a contractual dispute is a negotiated settlement. So the question is basically asking, is a mediated settlement the same thing as a negotiated settlement?
True.
Ooh, that one's false.
No, that's correct. That's correct. I just wrote down the wrong answer.
Oh, Brad! Wow, he is really throwing us some curveballs. So you're right, Mary. You are right.
She has a good sense of humor too.
All right, 2 more questions. Associations should never ignore contract deadlines.
True.
And associations should always go with the lowest bid.
False.
Perfect. Wow, that's really good. So she's got 21 out of 22. I think that's a new record.
Ask her the follow-up question. What is the
the
tiebreaker?
Oh my gosh. Mary, we're going all out. We're asking you every question we could possibly think of. So the
Mary,
last
get
question
this right,
is...
we'll throw an extra $25 in. How about that?
Okay. That can be bought. That's
Do you like that, Mary?
Yep.
So this is the last question. Associations should be aware of manufacturer's warranty language.
True.
Perfect.
Mary, what can I say? You performed excellent.
She's
in
a
our
star.
Yes, you are a star, and we really appreciate your support, and we really like you listening, to the Saturday HOA Brunch.
And only 6 months on the board. We've had a lot of board members, Mary, that have been on their board for 20 years, and you did better than them. Fantastic job.
Well, I learned a lot. I learned a lot today. But I've been working with I've had a lot of work done on my house, and I have a great contractor, and a lot of the things, almost all the things you covered today, have already been in his contract, his statement of work.
Oh, that's good.
Yeah,
I've got a great contractor and he's
Stand-up
educated
contractor.
me, so-
And it shows you
so
did a good
have
job with your contract, so that's great. So you have a nice foundation for being a good board member.
Hey, Mary, I'll get a hold of you this week. We'll get that gift card shipped out. Have a great weekend, huh?
Okay, thanks for inviting me.
No worries.
Thank you.
Okay, bye-bye.
Bye.